For instance, it's the second installment explaining what happened with the Supreme Court the other day in refusing to grant an emergency stay to prevent the Texas abortion law from going into effect. And while the fact that the law went into effect is great news, and we should rejoice in it, I think there's something fundamental underlying the opinion of the 5 justices that denied the stay that has profound implications going forward, and it's being overlooked. What the court said, at least among those 5 justices, has the potential to put our constitutional house back in order going forward. You see, here's the thing. The United States Constitution in Article 3, Section 2 specifically states when the federal judicial power can actually be used, exercised, when it's properly invoked. And it says this: the judicial power shall extend to all cases, and then it goes on to explain certain kinds of cases, and to controversies, and it explains certain kinds of controversies. This is the lawyers refer to this as the case or controversy requirement. In other words, the court can only exercise its powers when parties come before the court who have an actual concrete dispute between them involving the law, and depending upon how the law is interpreted, one or the other of them will be subject to an order saying do this or don't do this. That's all. So, for example, you may have heard the word advisory opinions. Here's what this would mean. If I were a Tennessee legislator, I couldn't say, I'm interested in passing this law in Tennessee, so I'm going to go down and sue in Texas to find out if that law is constitutional before I spend my time trying to pass it here. Well, the Tennessee official couldn't do that. One, the law only allows citizens of Texas to sue, okay, under that law. Well, I'm not one. I'm not an abortion provider, so I can't bring the lawsuit on that guy's. I'm not a state official, so I can't bring the lawsuit. So the Supreme Court, even though I might be very interested and have all kinds of good reasons for why I need to know if the Texas law is constitutional, they'd say, we don't have an actual case or controversy involving you. Now, here's the first thing the court said that is so fundamental to the potential of restoring constitutional order in our country if just our state elected officials understood it and would use it. The court said this: this case presents complex and novel antecedent procedural questions to which they've not carried their burden. So in other words, prior to the question of whether the law is constitutional, there are certain procedural questions that have to be answered. And they're referring here in specific to the case or controversy requirement. The next sentence reads this way: for example, federal courts enjoy the power to enjoin individuals tasked with enforcing laws, not the laws themselves. Now that is a huge statement. And if we just understood that, if federal courts would just abide by that, if state officials would just abide by that, how much better off we would be. In other words, the Supreme Court cannot repeal a law, a state law. It can't strike down the law. It can't rewrite a state law. All it can do is say, if David Fowler sues the governor over a certain law the governor is required to enforce, then the court can say to the governor, you can't enforce that law to David Fowler. But that's all. The court can't say, now, governor, you can't enforce that against anybody else. Why? Because there's not a case or controversy involving anybody but me or the governor. Does that make sense? Now let me put this in a different context with the Supreme Court's marriage decision. In Tennessee, same-sex couples sued the governor to say, we got married out of state and you won't recognize our marriages. And the court said, well, that's unconstitutional. But the court said nothing about the license law that county clerks are supposed to enforce. County clerks treated the law as if the Supreme Court had spoken to them, and they weren't even parties in front of the court. And the court can only speak to parties. It can't just say the law in general is suspended. It can only be suspended as to particular individuals in its enforcement. And they can't rewrite a law because all they can do is issue judgments. Only legislative bodies can make laws. Oh, my friends, If we just understood this first sentence in what the Supreme Court said, how much better off would we be? Instead, what happens is state officials take a decision against another state official and decide that it somehow applies to them as if the judgment and the order were entered against them. And it does not, and it cannot. Oh my. Now, the governor of our state, for example, may choose not to enforce a law that's identical to the one that was enjoined from enforcement that the governor in another state couldn't enforce, but he does so because it's prudentially wise not to do so. In other words, I think the reasoning of the court is solid, it's well grounded, it's rooted in the Constitution, it's rooted in our history and our traditions, and if I were to continue to enforce our law, I would probably lose, so I'm going to go with it. But when the Supreme Court issues an opinion that has nothing to do with the text of the Constitution or the common law or our history or anything and is contrary to their prior precedents, a governor in another state could say, well, I think you got it wrong. And I think the governor of that state made a stupid argument, and I'm going to make a better one, and I'm going to continue to enforce my law because I have the constitutional power and right to do so, because the court's judgment did not remove anybody's law. It didn't even remove the law of the state where it was enjoined from enforcement by that governor against those particular people. It sure didn't enjoin the law of the state of Tennessee. And I'm going to continue to uphold the law of the state of Tennessee. That, my friends, is huge. And 5 justices said that.